Good evening. Sorry I couldn't talk to you earlier, but today I had a meeting of the Soil and Water Conservation District, and I also had some paper to get out, so it was dark. And I didn't even look at what the current stories were until later. And this is a story that I think is all absorbing. I think it puts us at a point where we see the misconduct of the administration. We see them using power to wrong ends. And we see people reacting to it and fighting back. What I'm talking about is the decision by the Southern District of New York, prosecutorial office, its leadership, saying they won't do what Maine Justice wants them to do. And what exactly is that? Maine Justice is just a name for where they are physically. Justice could never be further from the truth under the current administration, headed by Bondi, B-O-N-D-I, who was recently approved by the Senate. And she was nothing but a political shill for Trump, as long as we can remember, going back to the 2015-2016 election. And now she's in place, having told the Senate under oath how she would conduct her office. And now we have how she's going to conduct her office in a case involving the mayor of New York, Eric Adams. This is what the Maine Justice wanted to do. Maine Justice wanted to have the case dismissed against Eric Adams. They wanted it dismissed because, well, he's going to help us with the immigration problem. And, there's an election coming up, and this would interfere with that. Well, how did Maine Justice find its dealings with the Southern District of New York? Now, let me tell you something about the Southern District. It is where I was an assistant U.S. attorney. I was honored and privileged to have that opportunity. And when I was younger, there was a lot of corruption in New York that was the subject of investigation. And if I had two footstools of interest, one was science and math because of Sputnik, but the other was because of JFK and because of men and women that I saw as models for fighting corruption in our political process. So I wanted to be in the Southern District of New York, and I wanted to be in the criminal division, and I wanted to be in the corruption unit. I couldn't tell whether I would achieve those things, but I was persistent. Why did I want to go to that office? The reason was because there was a U.S. attorney, Whitney North Seymour, who was in charge of that office. And he found what he thought was corruption under the guidance of Rusty Wing, a prominent assistant U.S. attorney in the office, and a person I was proud to know and to learn about. He's still with us. I don't mean to sound, because of our separation, like he's separated from all life. And what Whitney North Seymour did, which was impressive, was he went forward with the prosecution of the Attorney General of the United States. That is his boss. He actually brought a challenge against his boss, the Attorney General, and there was an indictment in the Southern District of New York, which is New York City and points north. And I thought that showed a lot of nerve. He also said to the assistant U.S. attorneys in his office at one point that, if you guys want to be loved, get yourself a Cocker Spaniel, because the duty of this office to this function is quite important, and you can't be concerned about people naysaying you for the choices that you make under the law. This case involving Eric Adams is precisely that kind of case that Whitney North Seymour was involved in, and he was a Republican, and the office has had a reputation for being partisan blind, if you will, when looking at cases. For one thing, you can look at the fact that if you want to say it was Democratic, you could say certain things about it. But let's talk with the acting U.S. attorney. Danielle Sassoon has been in office, and she has been responsible for this case. And she is the one who responded to the Department of Justice. How did she respond? She resigned. But she didn't resign quietly. She wrote an 8-page letter describing why she was resigning and what was wrong with what was going on. Now, the head of ethics in the Department of Justice, he also resigned. And then as well, the acting U.S. attorney, when Danielle resigned, he resigned. And three more, as I understand it, three more Justice Department people have resigned over the fact that the main justice has pushed this case. Now, what I'm going to do, which may be a little unusual, is I'm going to talk a little bit about the detail, and I'm going to read from her note, and I would encourage you to do the same. Now, why do I say this is important? The clash of the merits of a case, of the application of the law to the facts, that are the only things that should drive a prosecution, are not what Department of Justice wants to do. And I would highlight two people in particular. One is Bondi, and she is the Attorney General approved by the Senate. And then there was one, Bove, B-O-V-E, who is the acting Deputy Attorney General, who has been making the demand on behalf of the Department of Justice, and Danielle has been the person making the response. So you have a sense of the players. Ken Briscoe was the top prosecuting attorney in the public integrity section in Main Justice, and John Kelly was the acting head in New York. I say these names, and I'm not actually familiar with them because it's been years since I served in that office. But I was very concerned that we were going to make the wrong choice there. When I say we, I'm talking in the sense as if I'm still an assistant. But as a person who's concerned about the integrity of law and how we prosecute cases, and that no man be above the law, and that we have equal justice before the law, I've always been proud of the people who've been in that U.S. Attorney's Office. I know from my experience what I learned there and so forth made a difference in how I do the law and have ever since that office. And I think that any of us, if we find we have certain ability, it's as a result of the experience we have and the people we listen to and the cohort of people that we work with. Now, I have before me, and so you'll have to forgive me for looking at it, but I want to report this accurately. As far as I know, this information became public, that is the reaction of the U.S. Attorney in the Southern District of New York this evening. And it's an 8-page letter dated February 12th, 2025, although my understanding is that maybe it only became public on Thursday. So that's a process detail. In the first paragraph of the letter that Danielle wrote to the Attorney General Bondi, she said, "I do not repeat here the evidence against Adams that proves beyond a reasonable doubt that he committed federal offenses. Mr. Bove has never called into question that the case team conducted this investigation with integrity and that the charges against Adams are serious and supported by fact and law." That's critical, because not only do we have her making a statement about the case itself, she's also stating that the Justice Department has removed any question about the integrity of the people involved in the case, which is not how Trump and his minions and the Justice Department has been handling these firings. These people are fired without any proof at all, whether it be the FBI or career prosecutors. And why? Because we want supple people to do what we corruptly want to do. That's what this is about. And when you lose the Department of Justice, in this case, the way they're doing it, who they are, that means we're losing just us. So the just us members of the Justice Department are compromising the security and safety of America when they look the other way when people are committing these crimes. She said that, "I am guided by, among other things, the principles of federal prosecution set forth in the Justice Manual, and your," writing to the Attorney General, "your recent memorandum instructing attorneys for the Department of Justice to make only good faith arguments and not to use the criminal enforcement authority of the United States to achieve political objectives or other improper aims." How many cases in this country while Trump was running for office were kicked to the side of the road instead of following these principles? Too many. Now, there is in the federal rules a Federal Rule of Criminal Procedure 48A. Okay, now I'm not going to turn this into a clerkship memo to you as judges. I'm going to just give you enough information so you can decide for yourself whether or not this is stripping away from the pretense of regularity that this is a corrupt organism in the Department of Justice, and this case proves it. Particularly, think about it. This is a world-renowned case. We're talking about the mayor of New York City. Okay, could it be Tokyo? Yeah, it could be Tokyo. It could be a bunch of things. It could be London, but it's New York City. It's our Justice Department. We're only weeks into this administration, and already when they say they're going to do favors for their friends and get their enemies list, this is Exhibit A. The rule says that the principal object of a leave of court requirement is apparently to protect a defendant against prosecutorial harassment. Example, charging, dismissing, and recharging when the government moves to dismiss the indictment over the defendant's objection. Now, what they're talking about is what Main Justice wants is it wanted the Southern District of New York to say to the judge handling the case, we move to dismiss this case without prejudice. Without prejudice meaning we could bring the case down the road. And so what is that about? Well, from the standpoint of the transactional relationship between DOJ, Trump, and the mayor of New York, what that means is I can hold this over your head, and perhaps I'd like you to deliver on the immigration program. And I'm giving you a leg up on your election as part of the consideration. And in this letter, she does use the terms quid pro quo. He's getting a leg up so that he might get reelected as mayor and be able to proceed as a less independent person now coerced by Trump. I mean, this feels like a mob story anyhow. So there are two main points that Main Justice made to the Southern District of New York, and they are outlined in her letter in response, that is the U.S. Attorney. Said Mr. Beauvais proposes dismissing the charge against Adam in return for his assistance in enforcing the federal immigration laws, analogizing to the prisoner exchange in which the United States freed notorious Russian arms dealer Victor Bout in return for an American prisoner to Russia. Now, such an exchange with Adams violates common sense beliefs in the equal administration of justice, the Justice Manual and the rules of professional conduct. The commitment to the law is nowhere more profoundly manifest than in criminal justice. So, federal prosecutors, she writes, may not consider a potential defendant's political association, activities, or belief. And she makes this logical point. If a criminal prosecution cannot be used to punish political activity, it likewise cannot be used to induce or coerce such activity. Threatening criminal prosecution, even to gain an advantage in civil litigation, is considered misconduct for an attorney. Now, this is Trump's go-to manner. We saw it with Ukraine, and where he wanted a favor. And what did he want the favor for? Well, in exchange for an investigation of Biden, who was obviously going to be, in the 2016 election, a very likely and most powerful opponent. So that, and then we even had his press secretary say, well, what's wrong with quid pro quo? We do that all the time. And the prosecutor, Danielle, writes, Mr. Bove's comparison to the Bout prisoner exchange, which was quite expressly a quid pro quo, but one carried out by the White House and not the prosecutors in charge of Bout's case. So even with that analogy, she separates the fact of the quid pro quo, but she also says that that's not what we do. Our limitation is to look at the facts and the law and the conduct and the strength of the case. That's what we do. That's what we do as prosecutors. Now, the Main Justice wants to suggest that other prosecutors in the case had an angle on this. You've heard them talk about they're weaponizing the Department of Justice, and the prosecutor in the case made it pretty clear, Danielle, that look, you said the team was flawless in terms of its operation and so forth, and you have these other two concerns, one of which is to assist in the immigration problem in New York. And they mention as well that we got to be concerned about when we're going to try this case. And her answer was, there's more than 9 months to the primary, the June primary. So what are we talking about? And they cited other cases and how they were intertwined with schedules, including the Menendez case, which just recently ended with a conviction and an 11-year sentence, and that was tried in the Southern District of New York. So Danielle, the prosecutor, poo-poos the notion that this is going to interfere with the election. And they said, Mr. Bove specifies that Adams must consent in writing to dismissal without prejudice. Well, that's fine, but that doesn't answer the question. And it is possible that if such a motion was made, the judge would inquire about it and might decide to deny that, as it could be. So, because the law doesn't support a dismissal, Danielle said, I am confident that Adams has committed a crime with which he is charged. I cannot agree to seek a dismissal driven by improper considerations. And it's interesting because she quotes Justice Robert Jackson, and he was on the Supreme Court, but he was also involved in the Nuremberg prosecutions. And what he said about the role of a prosecutor is that the prosecutor at his best is one of the most beneficent forces in our society when he acts free from malice and from other base motives. And when he acts from those, that is, from malice or other base motives, he's at his worst. And that's the concern here. And, you know, it's been terrible that the discussions have been bereft, if you will, of these kinds of considerations. And those who have followed my remarks will remember that I thought that our special counsel shouldn't have thrown in the towel so easily. We should have fought it. We should have illustrated what the conflict was, because we inform and educate and advocate to our people what the values of our society are when we let those marinate in our common discussion and our talking here. So what do we have? We have an update, if you will, of what happened in Watergate. There was I believe it was the Saturday Night Massacre, and Nixon had fired the special prosecutor. Well, he demanded that he be fired, and they had to go through several people of the Justice Department who refused to fire him until they got one. And he later was nominated to join the Supreme Court. And the outpouring in a more bipartisan period, where I think the ethics and the politics and the rule of law and proper conduct held sway more strongly. And so he was not approved, and he forced a vote on the floor. And I once had a conversation with him right outside the steps of the courthouse. And it was like he didn't understand that his bad faith concurrence with Nixon to fire those people should have prevented him from going on the Supreme Court. We're a long way from that with the current Supreme Court. So what do I think is at risk here? What I think is at risk is tempered by the resignations, by this 8-page letter, by the discussions that will follow. I was very concerned myself, as much as I have faith in that office, that they would succumb. And you may remember that when Barr was the Attorney General, he intervened with the prosecutor Berman, the U.S. Attorney at the time, because he didn't want to have Trump prosecuted. He wanted certain things to happen, and Berman remained steadfast, and they offered him a position which he poo-pooed, and ultimately he was out of office, and he wrote about it in a book. This is a different scenario. In this one, we have what you call a noisy resignation. When people resign quietly, I don't know that it has that effect if people are guessing, why did you leave? In this case, Danielle Sassoons has made it very clear what her reasons are, what the circumstances are, why it doesn't make sense, and why it's in fact corrupt. She does it in a, how would I describe it? Well, kind of like Jack Webb, nothing but the facts, but it's also the facts and the law and the policy and the considerations. I think one way to describe it is she has set forth the reasons for refusing to dismiss the case in very clear language. Not only talking about the facts, the value of the case, and that the two bases that the main justice wants to dismiss the case are not valid reasons to dismiss the case. What does this mean going forward? This may not be the shot heard around the world, but there will be many people, myself included obviously, who find this standing up to improper exertions of power where the authority and the law and the Constitution and decorum and good faith do not go. So, I apologize that I went on too long. I hope I was clear enough. I try to pride myself in being, my greatest strength and weakness, I probably have said this before, is my clarity of expression. So, but I borrow from Danielle, and I'm very proud to be associated with the way she's handled this. And the only other way I could see you could handle it differently, which is more difficult under the circumstances, would be to have gone to the grand jury and gotten an indictment. But that might have been a different kind of fight. And I'm sure they debated this carefully, and there were some late night discussions about what this means in terms of career and so forth. But I would bet, and it may be retold and recounted in the days ahead, I bet you Danielle had no qualms or reservations. This was the only thing she could do. And that's the character that we want in our public servants. That's the force of expression we want to explain what's really going on. That is the kind of person we emulate. And if Whitney North Seymour can call upon the Attorney General and prompt an indictment against his own boss, then Danielle Sassoon can tell Main Justice, take a hike. You got it wrong. Pound sand. I'm not doing this. I'm not going to be a puppet for misconduct. By the way, those words are mine, but I think you can infer pretty easily that the strength of her resolve is on behalf of the rule of law, taking her where the facts go and what the policy is for how you deal with a sitting mayor of one of the major cities in the world. So, thank you for listening. I hope you found this interesting, and I'll be back tomorrow, and I expect to be about while there's still light out. And for all you people out there, happy Valentine's Day. All the best. Bye-bye.